Thank you for joining me for the first of 4 recordings covering an introduction to international criminal law within the context of our public international law course. I'm going to introduce some key concepts and questions and look at the history and sources of international criminal law before turning on to looking at the core international crimes in outline, and then we'll have a case study on the crime of genocide and also look at the question of who can be responsible for international crimes. How do we connect particularly leaders to crimes they might be physically and structurally remote from? But let's start by attempting to define our topic. What do we mean when we talk about international criminal law? There are several possible approaches here. The first is we might think of international criminal law as being about those crimes that are subject to universal jurisdiction. The idea that these are crimes of concern to the international community and any national court can prosecute them. Universal jurisdiction is something we will come back to later in the course, but the thing to note for present purposes is that there are a number of offences that are potentially subject to universal jurisdiction, which go beyond the kind of crimes we normally think of as being at the heart of international criminal law. And these include both certain crimes under treaty, where there's jurisdiction to prosecute the acts of foreigners committed in foreign territory, torture being a classic example, and also the historic crime of piracy. The other possibility is we could say that international criminal law covers any crime arising under a treaty, but this would include a number of relatively minor offences, including, for example, intentional damage to submarine cables, as well as every terrorism suppression convention, for example, the Convention on the Hijacking of Aircraft. So the usual approach that winds up being taken to international criminal law is to focus on the crimes that can be prosecuted before international courts. This results in a focus on what are commonly called the core crimes of genocide, crimes against humanity, war crimes, and aggression. And as I've said, we will cover all of those in a very outline way before looking at genocide as what is often regarded as the principal or most important of international crimes at present. So, how has international criminal law come about? We can only cover the history of international criminal law in a very brief fashion here. But the common starting point is often said to be piracy, that this is the first example of an international criminal. And it's certainly an example, a clear example of universal jurisdiction. Every state and every state's courts have jurisdiction to prosecute a person suspected of piracy. But this is now more commonly seen as an example of a transnational crime rather than international crime. What do I mean by that? We often speak now of international crimes as being those that somehow shock the conscience of humanity. They somehow engage the interests of all human beings because they are so particularly morally egregious or appalling. Piracy often involves little more than theft or occasionally kidnapping for ransom on the high seas. It is not a particularly extraordinary crime. The only particularly international thing about it is where it is committed on the high seas outside the jurisdiction of any state. So piracy is essentially a crime that crosses borders because a ship on the high seas is subject to the jurisdiction of its flag state, and piracy involves attacking a ship on the high seas from another ship. So you are, as it were, crossing into the jurisdiction of another state in committing piracy. Further, the rationale for the law on piracy is fairly pragmatic. If you didn't have rules allowing universal jurisdiction, and particularly universal police action on the high seas against piracy, it would be a very difficult crime to detect and prosecute. So piracy is not really a particularly good foundation for modern international criminal law. There are a number of historical examples of trials for international crimes, particularly the so-called Leipzig trials in Germany of German war crime suspects after World War I, but far more prominence is usually given in history to the Nuremberg International Military Tribunal of 1945 and the International Military Tribunal for the Far East, the Tokyo Tribunal, that ran between 1946 and 1948. So these are often portrayed as a pivotal turning point when international law suddenly reaches inside the state and attaches direct rights and obligations and consequences to the actions of individuals, rather than stopping with the responsibility of the state itself. Nonetheless, these have not been particularly influential on subsequent developments. They are not often quoted as precedents. The Nuremberg Tribunal in particular, while it conducted what's now largely regarded as a fair trial and an exhaustive examination of the evidence, didn't engage in a great deal of sophisticated legal reasoning. Also, despite one of the principal crimes of the Nazi regime now being universally acknowledged as the Holocaust and action taken to exterminate the Jewish population of Germany and occupied territory, but also the liquidation of persons who are disabled or elderly or of Roma origin. Despite all of that, genocide was not one of the crimes within the jurisdiction of the Nuremberg Tribunal, and it's only referred to in passing. Also, it had a peculiar limitation in its statute, where it could only prosecute crimes against humanity that were connected to the war in Europe. So there was an attempt to kind of link crimes against humanity with war crimes, because it was a newly emergent category at the time. That is, there was no prior history of crimes against humanity being prosecuted before the Nuremberg Tribunal. So there was a delicate question there about the retrospectivity of some of the law it was applying. So it stands principally as what was called at the time by Justice Robert Jackson of the US Supreme Court, who was the lead prosecutor for the Allied forces at Nuremberg, as a practical precedent, a precedent in the sense of having demonstrated what he called the power of the beaten path. Once you have done something like this, it will be easier to do again. So Jackson thought that the practical precedent set by Nuremberg was that you could have international criminal tribunals in the future. However, we had to wait the better part of 50 years for the next set of international criminal tribunals to arise. We had the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda, established by the Security Council in response to the wars of dissolution and the ethnic conflicts in the former Yugoslavia and the genocide in Rwanda. And the jurisprudence of the trial chambers and the joint appeals chamber of those two tribunals has played a far greater role in the development of international criminal law. There's also a very special role that can be attributed to the Rome Statute of the International Criminal Court and the elements of crimes. So the Rome Statute itself is a treaty, and the elements of crimes are a subsidiary document created by the state parties that guides the court in the interpretation of offences under the treaty, although the treaty itself always has precedents. Now, the point about the Rome Statute is that 148 states were involved in negotiations, and the final text was adopted by a vote at the negotiating conference, with 120 votes for, 21 votes against, and 7 abstentions. And at November 2011, it had 120 state parties to the statute out of 193 UN member states. So there's an interesting question about the extent we can look to the statute either for evidence of opinio juris, the opinion of states as to the legal content of international criminal law, and also the definition of crimes, and in particular the elements of crimes document add significant detail to the offences. Also, as the International Criminal Court now has a greater caseload, it is assuming an increasing importance in shaping international criminal law itself. This leads us to my next question: how do we identify the sources and relevant principles involved in international criminal law? So we have to be careful here. We can say war crimes are contrary to customary international law, or the prohibition against genocide is jus cogens, but how does that help us in a criminal court? A criminal court will want to identify specific and precisely phrased rules capable of being applied in a criminal proceeding. So criminal law expects precision and has the underlying principle or assumption of nullum crimen sine lege. You can't punish something that has not been established in law, and preferably established with a high degree of precision. But international law is often quite imprecise, particularly if we think of customary international law. So we might be able to make the general statement, war crimes are contrary to customary international law, but how do we identify the content of war crimes? Well, we'll certainly be tempted to look to treaty-based law, because treaties will be more detailed, but may not bind all states. Now, certainly, the Geneva Conventions of 1949 lay out the law applicable in war and have near universal or completely universal membership. You would be hard-pressed to find a state in the international community that is not a party to the Geneva Conventions. But a further difficulty with the Geneva Conventions is they were not originally designed as crime-creating treaties. As we'll come on to, they were designed to lay out rules of conduct in war, and only a few provisions envisaged criminal sanctions for their breach. Further, a difficulty that may arise is that international criminal law brings together or draws from different branches of law and public international law, and these may have conflicting imperatives. So, international criminal law involves engagement with law and principles drawn from criminal law, human rights law, the law applicable in armed conflict, and general principles of public international law. And it may not always be easy to reconcile all of these different standards. Criminal law may expect a degree of precision that the law of armed conflict may or may not have, for example. Human rights law aims to be protective of individuals, whereas criminal law will often aim to be protective of the rights of a defendant. So there may be a number of different imperatives that have to be reconciled. Alright, let's consider this in terms of classic sources of public international law. So treaty law will be important, and courts will often look to treaties first in a search for clear definitions. So the Rome Statute of the International Criminal Court and the elements of crimes will be an important source. But if you're looking to the treaty as evidence of general rules of international law, customary rules, you have to be careful, because the treaty that is the Rome Statute attempted both codification of pre-existing law and progressive development of the law. So not everything was intended necessarily to reflect pre-existing law. But certainly where, for example, the Tribunal for Yugoslavia has interpreted customary law, and that rule has then been adopted and taken up in the Rome Statute, that might be thought good evidence of the international community having come to accept a new customary rule, for example. Also, in terms of sources we might look at, I've said the Geneva Conventions are very important to the law of war crimes. The Genocide Convention is generally taken as, in its important elements, codifying the prohibition on genocide, and the Torture Convention is also an important source of law. Now, in terms of customary law, that has also had an important role in the development of international criminal law, and as I've mentioned, the Geneva Conventions largely state rules of conduct. They say this is what it is acceptable for states to do in the course of war. However, only a handful of violations had criminal sanctions attached to them, the so-called grave breaches provisions, and those provisions only applied in international armed conflict. We'll come back to the important distinction between international and non-international armed conflict. But you had only a limited class of crimes applying in a limited class of conflicts under the strict black letter interpretation of the treaty. However, there is a broader category, the laws and customs of war, which obviously includes customary international law, and the Tribunal for Yugoslavia was given jurisdiction over both. So the question was, have other rules found in the Geneva Conventions become part of customary law? And the ICTY case law has been important in that it has significantly expanded the range of war crimes that can be punished, particularly in the case of non-international armed conflicts. Customary international law has also been important in areas other than the law of substantive offences. Another important part of international criminal law is the law of liability, the law that tells us in effect who can be responsible for war crimes, genocide, crimes against humanity. And on this point, the Tribunal for Yugoslavia was faced with a very limited statutory provision, referring to committing crimes, ordering crimes, aiding and abetting crimes, and so on, but without providing much detail. So it looked also to customary international law and found that doctrines of liability such as joint criminal enterprise, what would be called joint enterprise doctrine in the United Kingdom, were part of custom and that it could apply those as well. Also, the decisions of national courts in international criminal law cases might be looked to as evidence of customary international law or for guidance on approaches taken to the interpretation of a treaty, such as the Genocide Convention. Right. Another source that has a somewhat different role in international criminal law than it might have in general public international law is the source General Principles of Law. So, for example, international criminal tribunals will use general principles of law to plug a gap in the applicable law when there is no applicable treaty rule and no applicable customary rule. So it can only be resorted to after you have exhausted treaty and custom. How might this work? Well, for example, it was acknowledged that rape is a war crime. That was an uncontroversial proposition. But to prosecute rape as a war crime, you need a definition of rape. So in the Forenzija case, the ICTY engaged in a survey of the law of rape in various national legal systems. And it did that not to deduce a universal rule of customary international law, but as an exercise in discerning common general principles as to the actus reus and the mens rea required for rape. Another relevant source is going to be case law. International criminal tribunals will tend to refer to each other's case law and sometimes the decisions of national courts. Of course, such precedents are only persuasive, they're not binding. There's no hierarchy between international criminal tribunals. But, for example, where an international tribunal has already reviewed state practice and opinio juris to discern a rule of customary international law, that forms what Darpo Akande has called an off-the-shelf assessment, and courts will be very tempted to rely on it, or at least will feel obliged to distinguish it if they don't follow it. In any event, the first source of law for any international tribunal will be its own statute, and that may create important differences in the applicable law between different tribunals if the offences covered or the modes of participation in crimes are defined differently between them, and that might be a limitation on the ability of tribunals to look at each other's case law. We also need to consider the role of soft law. So, for example, in the law of war crimes, the work of the International Committee of the Red Cross may be influential. So, to take one example, under the law of targeting in the law of armed conflict, it is legal to attack persons taking direct part in hostilities, even if they are not, for example, part of a regular military force, or even if they are otherwise civilians. The question then arises, well, what does direct participation mean? Well, the International Committee of the Red Cross has issued interpretive guidance on point. So this is at best a soft law source, but one can expect that it would be looked at by an international court in assessing what direct participation means. Also, as I've already mentioned, the Tribunal for Yugoslavia has jurisdiction over violations of the laws and customs of war, which raises the question, what crimes are now recognised as war crimes under customary international law and state practice? And what constitute, more broadly, the customary rules of war? Well, again, the Red Cross has published a somewhat controversial study on customary law and armed conflict. Obviously, that goes beyond the question merely of what are crimes in armed conflict. But in any event, it was controversial because some critics considered it put far too much reliance on military manuals, i.e. what states say, rather than direct evidence of compliance or non-compliance with rules, which we might consider evidence of what states do. Finally, we need to consider how certain important criminal law principles interact with international criminal law. So, I've already referred to the principle nullum crimen sine lege. There should be no crime that is punishable without there being prior law. And it's perfectly open to defendants before international criminal tribunals and their lawyers to say that judges in interpreting vague treaties, discerning rules of custom, or discerning and applying general principles of law are making law for the first time, and that is a violation of nullum crimen sine lege. And it's certainly possible for defence lawyers to ask legitimately, how can they run an effective defence if the law is so uncertain, if in some cases it appears to be a moving target? A number of answers can be made in response to this, which one might find more or less fully convincing. The first is that international criminal law in its modern sense has only been running since the early 1990s, and some of that law is simply going to have to be judicially made, and that comparing that directly to modern legal systems with highly developed codified systems of criminal law is perhaps unfair. We might also say that we've now reached a point where the International Criminal Court statute provides a much more thorough and detailed account of the applicable criminal law than did the statute for the Tribunal for Yugoslavia or Rwanda. Well, that completes our brief outline of the history and sources of international criminal law, and in the next couple of sessions we will look at international crimes in outline, the core crimes, war crimes, aggression, genocide and crimes against humanity, before moving on to our case study on genocide in particular. Thank you.